Hi, I'm Trisha Dunlap with Dunlap Law, a small business law firm in Richmond, Virginia. I'm here today to talk with you about your employees and political activism. Can you fire somebody if they're posting things on social media that are political and perhaps damaging to your business? The short answer is yes, you can, but there are exceptions. First of all, let's talk about the basic idea of the First Amendment. A lot of people get really up in arms and start yelling about the First Amendment the minute anybody tries to censor or limit their speech. And oftentimes Americans don't understand that the First Amendment limits only actions by government. The First Amendment does not apply to private sector businesses except in some very narrow exceptions, which very rarely are going to apply to your typical private sector business. So if you are a private sector business, the First Amendment does not limit your actions in censoring your employees' behavior. In fact, as an employer, you actually have a responsibility to limit some of your employees' communications in the workplace. For instance, if as an employer you fail to discipline an employee who harasses another employee either sexually or over their religion or ethnic origin, then you have failed in your duties as an employer and you could be liable for that. So interestingly, the First Amendment, not only does it not apply to private sector employers, but private sector employers have a duty in many ways to censor their employees' speech, especially in the workplace. But can you fire an employee for political activism that they might be engaging in outside of the workplace? And even there, the short answer is yes, most of the time. There are some exceptions to this. I'll talk about that in just a second. But particularly if you are an employer in an industry that is perhaps especially sensitive to political issues. For example, if you have a lot of government contracts that are the lifeblood of your business and you have an employee who is perhaps making political statements that could endanger your business's ability to hold on to those contracts, then you absolutely can fire that employee if you need to. Most employees, especially in Virginia, are what are known as at-will employees, which means you can fire them at any time for any reason, as long as you don't violate any of their protected, any of the protected classes. So, for example, it's well known you cannot fire your employees over their religion, their national origin, their ethnicity, their sex, and now also their gender and their status as LGBT, thanks to a recent Supreme Court ruling. So this is the one area where you need to be a little bit careful if an employee is speaking in ways that perhaps might indicate that they're in a protected class. That's the one area where you perhaps need to be cautious in firing an employee over their speech, their political speech. But as a general rule, unless they're in a protected class and they're speaking in a way that identifies them in a protected class, you have to be a little careful there. But otherwise, you can fire an employee for their political speech, either at work or even outside of work. The one other exception you need to consider is if there is a movement in your workplace to unionize, for the employees to unionize, then you need to be a little cautious there, because if an employee is engaging in, social media activism on behalf of the union movement, then and you fire them, then you could be retaliating against them as they're trying to form a union, and that's not allowed under federal labor law. Otherwise, outside of these few exceptions, you can fire an employee for their political speech. The First Amendment does not apply to private sector businesses. This is Trisha Dunlap with Dunlap Law in Richmond, Virginia. If this video has been helpful, please like, subscribe, and share. Thanks.